Hello everyone, welcome back to the channel Contract Simplified. I am Advocate Kritika here, and in today's video, we are going to discuss another important contract clause, the governing language clause. This clause specifies which language will be used for communication and interpretation of the contract. But, like any other clause, it can be misdrafted. Let's look at a governing language clause and then improve it. Let's get started. Here's a version of governing language clause which reads out as the language of the contract will be in English. All communication and documents will also be in English. At first glance, it seems okay. But this clause leaves out a lot of critical details. Let's break it down and see where it can be improved. Firstly, this clause only mentions the contract will be in English, doesn't specify official language for interpretation in case of dispute. What happens if there is an issue with how a term is understood? Also, there is no reference to local or official language of the party's jurisdiction, which could be important depending on location of the agreement. So now, here's how we can improve it. This agreement shall be executed in English, which shall be the governing language for all the purpose under this agreement, including interpretation and dispute resolution. All communication, notices, and documents exchanged between the parties shall also be in English unless otherwise mutually agreed in writing. In the event of a dispute arising from the interpretation of the terms of this agreement, the English language version shall prevail. The terms shall be interpreted based on their plain generic meaning in English. So now here we have improved in three areas. First one is clearer scope. It doesn't just mention the contract will be in English, but also clarifies that English will govern the interpretation and dispute resolution. We have added mutual agreement for other languages. That is, we have included a provision that allows the parties to agree use other languages in certain circumstances, but only if it is explicitly agreed upon. And precedence of English version in case of disputes has been upheld. We have added a statement that if there is a conflict between the versions of the contract in other language, the English version shall prevail. And this avoids confusion in multilingual contracts. This now ensures that there is no ambiguity about which language applies, especially in the case of a dispute. So here's what we have learned from this governing language clause. First, we have to specify the governing language very clearly for all aspects of the contract, especially for interpretation and dispute resolution. We have to allow for flexibility by mentioning that parties can mutually agree to use other language, but only with written consent. We have clarified the precedence of the governing language in case of discrepancies or translations. This prevents any confusion down the road. A well-drafted governing clause protects both parties and ensures clarity when it comes to the communication and resolving disputes. That's a wrap for today's video. I hope this helped you understand the importance of drafting a solid governing language clause that avoids confusion and ensures smooth communication. If you have enjoyed the video, don't forget to like, subscribe, and leave any questions or comment below. I'm happy to help. Thank you for watching, and I'll see you in the next video.